Well, hello and thanks for joining us. My name's Emma Cohen. I'm an associate solicitor here at OTB Legal. In a moment, I'm going to introduce you, or they're going to introduce themselves to my colleagues. Thank you for joining us for this webinar on immigration law, looking specifically at how it affects children in care. And we're going to share the presentation. I'll just give you a few housekeeping pieces of information. So we can't take questions as we're going along, but if you have a question, please put it into the Q&A. And at the end of the session, we plan to answer questions that you've put into the Q&A. If we end up with too many, then we will aim to come back to those of you that we can't respond to right here and now by email. And also, if you've got specific sort of case queries on specific cases, then please do contact us. And at the end of the webinar, we'll tell you how to do that. So I'm Emma Cohen. As I say, I'm an associate solicitor here at OTB Legal. I've been working in the field of immigration law for about 30 years. And quite a lot of what I do relates to children and families. And I've done lots of work with children in care and for local authorities. I'm going to hand you over to my colleague Callum to introduce himself.
Hi everyone, my name's Callum Standen. I'm a solicitor in the personal immigration team here at OTB Legal. I qualified earlier this year and I've been working in immigration law for almost 4 years now. And my areas of specialty, if you like, are across the family rules within the immigration rules and nationality applications as well. And I'll hand over to Laura.
Thank you.
Now as well.
Good afternoon, my name is Laura. I'm an associate solicitor here at OTB Legal in the personal immigration team, and I've been practicing exclusively in immigration law for over 10 years. I have expertise in family-based immigration and citizenship matters, and I'm experienced advising and working with local authorities when children they are supporting need immigration advice and representation. I'm going to pass you back to Emma, who's going to take us forward.
Okay, great. Thank you. Thanks, Laura and Callum. So if we move on to the next slide, I have to confess that this is a whiz through and we are going to cover a lot of material in a short period of time. So hopefully you will be able to keep up with us. But as I say, if you've got questions, please put them into the Q&A, and please do also get in touch with us afterwards if you've got other questions that we haven't been able to answer. So these are the areas that we're going to cover today. We're first of all going to take a quick look at common terminology that comes up in immigration cases. Then we're going to have a look at whether immigration advice is actually needed for somebody, a child in care. We're also going to touch on whether you as lawyers and social workers and people at in a local authority can provide immigration advice. Then we're going to look at the various applications that might be applicable for leave to remain in the UK, then at British nationality applications, then at visa applications for family members from abroad, which can often be quite relevant in care proceedings and when looking at who's going to look after a child in care. Then we're going to look at immigration advice in family court proceedings. And finally, we're going to look at more at the practicalities about the application process, timelines, fees and fee waivers. And at the very end, we're going to try and look into our crystal ball and give you just a bit of an idea about what the future holds, because I'm sure you're all aware that immigration is a very, very hot topic and there are lots of changes being threatened / anticipated all the time. Thanks. On to the next slide. So looking first of all at common terminology. And I suppose that what we want to just flag here is that there are lots of ways of saying the same thing. And the Home Office has tried to modernise its language, but it still falls back on using old language. And I have to confess that we as practitioners probably fall back on using old language as well. So there are a lot of ways of saying the same thing. First of all, when you are looking at someone's leave to remain, that might also be described as permission to stay. And in certain circumstances, particularly in relation to EU nationals, it's also described as pre-settled status. When it's to remain or to stay, it is permission that is granted inside the UK. If it's leave to enter, permission to enter, and actually pre-settled status goes across the board, then it's permission that is granted from abroad. But in both of those scenarios, it is time limited. So it will be a permission that has a defined end on a certain date. Then the next category, if you like, is indefinite leave to remain. And I think everybody is aware of that phrase, and that's been in the news quite a lot over the last few months. It's also described as settlement. It can be described as no time limit. Sometimes people describe it as permanent residence. Effectively, what that is permission which is not time limited, so it doesn't have an end date. And usually you don't lose it unless you spend a lot of time outside the UK or you commit a serious criminal offence, in which case steps might be taken to remove your indefinite leave to remain. Then a biometric residence permit. I'm sure you've all come across that as a concept and you've seen lots of them. Sometimes they're called biometric residence cards. Just to say, lots of people still have them, but almost all of them expired on the 31st of December 2024, and they are no longer issued for when new applications are made. Instead, people show their status by way of an e-visa. So everything is electronic now. And the e-visa is accessed via an account, a UKVI account. So you set that up electronically. And actually, I think we anticipated there being all sorts of horrible headaches with this when it came in. But so far, once people have managed to set up an account, it does seem to be a relatively easy way for people to show their status. And they can create share codes that enable them to show employers that they've got the right to work, or landlords that they've got the right to rent. And it is now being used for visa applications as well from abroad. So it is definitely the way forward. Biometric residence permits are a thing of the past. The next thing to mention is electronic travel authorizations, known as ETAs. And these are relevant for certain people who want to come to the UK to visit, and who don't need a visa to do so. They do now, however, have to apply for an authorization before they travel. So normally people who don't need visas are from countries that are not seen to be a threat to the UK in terms of immigration. And so it will be US nationals, for example, Australians, people from the EU. Everybody now who wants to come to visit needs to have an authorization that they show and that they give details of to the carrier, their airline or the ferry before they travel. Then entry clearance and visa applications. So these are concepts, these are applications that people make from abroad. Entry clearance is the old style name, I suppose, but it's still used a lot. A visa application is the more obvious name, but this is an application. Most people need to make a visa application before they come to the UK for permission to enter. And then it will now be approved, usually by way of an e-visa, but sometimes they'll get a sticker in their passport, and that needs to be in place before they travel. Very few people can travel without a visa now, and if they can, they need an electronic travel authorization. And then at the end of the immigration journey, we get to nationality. When we're talking about children in care, this is usually an application to register a child as a British citizen. The concept of naturalisation as British is a concept that is only available to adults. So most children will register. Okay, next slide, please. So then for you, often one of the big questions is immigration advice needed at all? So the first thing to do is to assess whether or not the young person that you're looking to help is already a British citizen, because if they are, it may be that they haven't got a passport, but they may be a British citizen, and then no further steps needed in relation to their immigration position. And Laura will be talking about nationality and ways to register children as British citizens a little bit later. If they're not British, do they have indefinite leave to remain or an ability to obtain it, or do they have settled status? That will usually be under the EU settlement scheme. Those, as I've already explained, are statuses which are not time limited, and Callum will be talking a little bit more about those. Just one thing to flag, and you probably are all aware of this, but don't assume that simply because a child was born in the UK, they don't need immigration advice, because their status will still depend on what their parents' status was, and they may not have been born British. So whilst there's Home Office guidance that makes it clear that children born here aren't here unlawfully, they are subject to immigration control. They do need to have status, and applications do need to be made for them, ideally before they turn 18. Then, as practitioners, you then need to consider, if you can't find out what you need to know from the child or from the family members, whether there's any way of finding anything out from the Home Office. And I'm sure you're all aware in care proceedings of being able to make applications to the Home Office for information, the EX660 process. I'm also aware of the NRPF Connect service, which I think local authorities can use to get information from the local authority, from the Home Office. So those are things to use to get information if you can't otherwise find out what is going on for a child. Then big question, how quickly should you act? And really the answer to that is as quickly as possible, particularly where you've got a child who doesn't have any status, because the more time you've got before a child turns 18, the more likely you are to be able to resolve their situation for them for the future. And the other thing just to bear in mind is that if you know that a child has got some form of limited leave to remain, which is time limited, just to make sure that another application is made for them before their permission expires. If that's done, then as long as it's made before their permission expires, they'll have something called Section 3C leave, which means that they continue to be in the UK with permission whilst their application is pending. Okay, thank you. Next slide. So this is something that has come up quite a lot recently, which is who's able to provide immigration advice, and can social workers provide immigration advice in relation to children in care? And immigration advice is quite strictly regulated, and that happened some decades ago now because of concerns about the poor quality of immigration advice that was available to people, and people paying a lot of money for advice that ended up not being very good. So now immigration advice is really carefully regulated by the Immigration and Asylum Act 1999, and people who provide immigration advice, broadly solicitors, barristers, advocates and legal executives, do need to be regulated, or people that work for those firms. If they're not lawyers, then they need to be regulated by the Immigration Advice Authority, the IAA, previously known as the Office of the Immigration Services Commissioner. And there are lots of firms and businesses out there who aren't necessarily qualified lawyers, but who are regulated by the IAA and who provide immigration advice. So then the question is, can social workers provide immigration advice? And the IAA guidance suggests that local authorities who've got court-ordered authority to act on behalf of a vulnerable adult or child in care can assist by providing free immigration advice or assistance, and that doesn't need IAA regulation, because the IAA is of the view that that assistance is given in a relationship which is akin to that of a parent or a family member with care responsibilities. Obviously, of course, lawyers in local authorities would be able to provide immigration advice and assistance. But do bear in mind that this doesn't extend advising all adults unless they're vulnerable. And arguably, it may not cover advice to children where there is no court order. So I think our view is that caution should be taken, and it may well be that you would prefer not to be offering this advice anyway, and that you'd rather get someone else to help. Next slide, please. So in fact, I'm going to now hand over to Callum.
Thanks, Emma. So yeah, I'm going to be talking a little bit about the different immigration applications that can be made. Just before I do that, I'm just going to cover two pieces of legislation that I suppose are overarching pieces of legislation that inform how the Home Office will assess applications. The first is Section 55 of the Borders, Citizenship and Immigration Act 2009, which outlines the statutory duty that the Home Office has to children when carrying out its normal functions. And essentially it includes the need to show fair treatment, which meets the same standard that a British child would receive. The child's interest being a primary but not the only consideration, and I'll speak a little bit more about that in a moment. No discrimination of any kind for asylum applications to be dealt with in a timely fashion, and identification of those that might be at risk from harm. And there is also guidance called Every Child Matters, which is guidance that the Home Office issues to staff in relation to Section 55 and their duties under the Act. There is a quote at the bottom as well. This is also taken from Home Office guidance about how immigration applications are assessed, and it makes clear that decisions about the future of any child in the UK in the care of the local authority should be primarily left in the hands of the Social Services Department, as they will be best placed to act in the child's best interests. And then the second piece of legislation is Article 8 of the European Convention on Human Rights. And that provides that everyone has the right to respect for their family and private life. This is a qualified right, so it's not an absolute right. And the effect of that is that the Home Office can restrict it if it is proportionate to do so. And what that means in practice is that the Home Office and then the courts as well will always carry out an assessment of whether it is proportionate to do so to maintain immigration control. It's quite a broad assessment, as the slide says, so it can cover obviously family life, but also things like physical and psychological well-being too. Just to come back as well about the child's best interest, it's a primary consideration. It's not the only consideration, which I think may be slightly different. Well, it is slightly different to what you may have experienced if you've ever assisted with proceedings in the family court. So the assessment there is that the child's best interests are paramount. So this isn't quite as it's not quite as strong, but it's still given a lot of weight and is still a primary consideration. Okay, so I'm going to talk a little bit now about limited leave to remain applications. So as Emma set out, limited leave to remain essentially is permission to stay in the UK, which is time limited for a specific period. As the slide says, as we've covered before, decisions are normally left primarily in the hands of the local authority and social services department, as they're considered to be in the best place to act in the child's best interests. If they think it is appropriate for the child to remain in the UK, the Home Office then will normally consider, or they will normally grant at least limited leave to remain to the child. Children in care, normally in our experience, will be granted 4 years of permission if they are granted limited leave. In theory, it could be shorter than that. It could be, in 12-month increments as well. But ordinarily, we would expect, if limited leave is granted, that it would be granted for a period of 4 years. Okay, so move on now to indefinite leave to remain applications. So these are the applications that are made, and if it's granted, then there is no time limit on the applicant's stay in the UK once the application is granted. So if someone has been granted a period of limited leave for 4 years, then so long as there is no prospect of removal still at the end of those 4 years, they can normally then make a further application, which, as Emma set out earlier, needs to be made in time before their permission expires. They can make an application for indefinite leave to remain, at which point their permission stay will no longer be time limited. There are also, I think in our experience, quite a few cases where it may actually be an option to apply for indefinite leave to remain straight away. And the Home Office will consider doing that if there are exceptional or compelling reasons to do so. So essentially it allows to almost skip the limited leave to remain stage and just go straight for settlement straight away. It's not straightforward to do that. And the Home Office set quite a high bar and make it quite clear that there must be sufficient evidence to demonstrate that the individual circumstances are not just unusual, but need to be distinguished from other cases as well. However, again, in our experience, most applications for children in care will have some kind of exceptional or compelling element to them that make a grant of indefinite leave to remain at least arguable. And if the Home Office don't grant indefinite leave to remain straight away, they will normally grant limited leave if they consider that the requirements are met for limited leave. So quite often, it may well be an option to apply for indefinite leave to remain from the get-go. And then just finally, the Home Office will also grant indefinite leave to remain to a child born in the UK where parental rights and duties are vested solely in the local authority. Okay, so there are other applications that can be made as well. So it is also possible to make applications on something called the private life route. Now, the private life route is not an application route specifically for children in care, unlike the applications I've just gone through. So the private life route, is available for children in the UK, potentially young adults or even adults that have been here for a very long time without regularising their status. However, there are circumstances in which a child in care may be able to make an application under this route, and we've identified three sort of scenarios in this slide, if you like. So the first is that if a child is born in the UK and is continuously resident here for 7 years, they can apply for indefinite leave to remain straight away under this route. As Emma set out earlier, just because a child is born in the UK, it doesn't automatically mean that they're British. It mainly depends on their parent status as well. So it may be that a child born in the UK to parents who aren't settled here, it may be that this is an option if after 7 years they've always been continuously resident here. If they're born outside of the UK, then a child could still apply under this route for limited permission. So they can do that if they've been continuously resident for 7 years and it wouldn't be reasonable for them to leave the UK. In most cases, even though in theory a route they could apply under this route, because this only grants settlement after 5 years rather than 4 years under the preceding provisions we've just gone through, it will normally be more appropriate to apply under the care provisions rather than the private life route. But in theory, it is an option. And then finally, for young adults, obviously everything that we're going through here, as Emma said earlier, I think one of the key takeaways is always to act fast and regularise a child's status as soon as possible. If that hasn't happened, then young adults may still, in theory, be able to regularise their status under the private life route if they make the application whilst they're over the age of 18 but under 25 and have spent more than half their life continuously resident in the UK, which is sometimes referred to as the half-life test. This also grants limited permission and it leads to settlement after 5 years on this route. And then finally, I'm just going to cover the EU settlement scheme. So the EU settlement scheme was a route that was opened up when the UK was in the process of leaving the European Union. So it's a scheme that's still available for children who are looked after and in care, who are EU nationals, other EEA nationals or Swiss citizens, or direct family members. The general expectation is that the applicant must have been living here in the UK on the 31st of December 2020. The deadline to apply under the scheme was actually quite a long time ago now. It's the 30th of June 2021. But the Home Office they are still able to accept late applications where good reasons are given for the delay. And the Home Office, as the slide says, the Home Office have made clear that late applications can and should actually be made under this scheme on behalf of the child or care leaver, and the Home Office will consider it as reasonable grounds for a late application to be made. If the child has been living in the UK for less than 5 years, they'll normally be granted pre-settled status, which again is this limited grant of permission. But once the child has been resident in the UK for 5 years, they can apply for settled status, which is the equivalent of indefinite leave to remain. One thing that the Home Office are now doing, they're in the process of automating the conversion of pre-settled status to settled status, where an applicant continues to meet the requirements. It's just important to note that if that doesn't happen, you still need to make an application to make sure that the child still has status before their permission expires. Okay, so that covers immigration applications. I'm now going to hand over to Laura, who's going to speak a little bit about the different nationality applications that may be available.
Thank you very much. So yes, I'm going to talk to you a bit now about citizenship and nationality matters. And first and foremost, is a child already British? So in order to determine whether a child needs support with their immigration matters, it's obviously first important to answer this question and determine the child's nationality and whether or not they may already be a British citizen. Important considerations will be the child's place of birth, whether inside or outside of the UK, and the child's parents' citizenship or immigration status at the time of their birth. Birth inside the UK is more straightforward, and a child will be British if either of their parents was British or had indefinite leave to remain at the time of their birth. But this question is slightly more complex where a child is born outside of the UK. And it's important to understand that there are two different types of British citizenship in the UK. One is known as British citizenship otherwise than by descent, and the other is British citizenship by descent, with the first, so that otherwise than by descent British citizenship being considered the stronger type that can be passed on from a parent automatically to a child born inside or outside of the UK. While the second type, the British citizenship by descent, is generally considered the weaker type, because it can only be automatically passed on from a parent if the child is born in the UK, and so can't be passed on if a child is born outside of the UK to a parent with this type of British citizenship. The two different types of British citizenship are acquired through different means. So British citizenship otherwise than by descent is acquired through birth, naturalisation or registration in the UK, while British citizenship by descent is acquired when a person is born outside of the UK to a parent who is a British citizen otherwise than by descent. Next slide, please. So if a child is not automatically British from birth, there is scope in UK nationality law to make an application to register them as a British citizen. And this slide sets out probably the 5 most common ways of making British citizenship registration applications. And I'm going to talk about each in a little bit more detail. But each of these require an application to be made to the Home Office for registration as a British citizen. And if that application is successful, the Home Office will issue the applicant with a registration certificate, and that certificate can then be used to apply to the Passport Office for a British passport. Next slide, please. So Section 1.3 citizenship registration applications. These are based on children who are born in the UK but are not British at birth. And if while they are under 18, either of their parents become a British citizen or are granted indefinite leave to remain, then they can apply to be registered as British, providing they are under 18 at the date they apply. And if that application is successful, they will be given British citizenship otherwise than by descent. Next slide, please. So Section 1.4 citizenship registration applications. These are possible where a person is born in the UK, is not British at birth, and lives in the UK for the first 10 years of their life without being absent for more than 90 days each year of that first 10-year qualifying period. Uniquely about these applications, they can be made by children or adults, unlike many of the other types of application we're talking about today. There's also Section 3.5 citizenship registration applications, and these are these provide scope in British nationality law for children who are born outside of the UK to a parent who is British by descent, so the British citizenship isn't automatically passed on at birth, for them to be able to apply to be registered as a British citizen where the child and parents have lived in the UK for 3 years during their minority, and they have not been absent for more than 270 days in that 3-year qualifying period. So the child must be under 18 when that application is made, and the parents must give their consent. And if the child is aged over 10, they must be of good character. There are similar provisions under Section 3.2 in the nationality law that provide where a British by descent parent has lived in the UK for 3 years prior to the child's birth, and then the child is born outside of the UK, that similar registration application can be made. Next slide, please. Thank you. So moving on, we've got Section 4L citizenship applications, and these are discretionary applications for adults to apply for citizenship, and these can be made where they would have been able to become a British citizen, but for one of these 3 reasons listed on this left-hand side here. So we've got historic legislative unfairness, 2, an act or omission of a public authority, or 3, exceptional circumstances. Now, while these applications are unlikely to be very common for your purposes, I flagged them here as the Home Office in their guidance do give an express example of when a 4L application may be appropriate. And they say whereby a child who was born in the UK and whose parents subsequently got ILR while they were a child, but the child missed the opportunity to apply to register as British under Section 1.3, as mentioned on the previous slide, solely because they were in local authority care from the age, in the example they give, age 11 to 18. The Home Office suggests that it would be appropriate to consider registering the child as an adult under Section 4L, owing to the local authority's omission in not getting the child registered when they were in their care and under the age of 18. So for the remainder of this section on citizenship, I will talk about discretionary child registration applications made under Section 3.1 of the British Nationality Act. And Section 3.1 in theory gives the Home Office a wide discretion to register children as British citizens, as is detailed here on this slide. And it expressly says, if while a person is a minor, an application is made for his registration as a British citizen, the Secretary of State may, if he thinks fit, cause him to be registered. In reality, however, the Home Office will only exercise this discretion under Section 3.1 in quite limited circumstances, as we'll go on to see on the next slide. So when will the Home Office exercise their discretion under this power? This is contained in the Home Office's own policy and guidance document, and in there they differentiate between children applying for citizenship at the same time as their parents and children applying separately to their parents. Briefly, when applying with their parents, the Home Office usually require the child to have indefinite leave to remain and have been resident in the UK for the last 2 years. When a child applies for British citizenship separately to their parents, under this provision, the Home Office guidance details these 3 scenarios when they will consider it appropriate to register a child as a British citizen on a discretionary basis. And each of these 3 have their own set of factors the Home Office will consider. And further in their guidance, the Home Office places quite an emphasis on the parent's circumstances at the time of any citizenship application. However, in our experience, this will be far less significant, if not irrelevant, if the child's parents are absent or not involved in the child's care. Next slide, please. So the Home Office guidance details these 2 scenarios we have on this slide of when they will normally grant a child's application for registration as a British citizen. They say where the child is settled and resident in the UK, the Home Office would expect to see 5 years lawful residence, that the child has settled status or indefinite leave to remain and has held that status for 12 months. The child's parents, if relevant, have 5 years lawful residence and have settled status themselves. And again, the child is of good character if age 10 or over and the parents consent. And the second one we have on this slide is where the child has lived in the UK for more than 10 years. The Home Office will take into account these considerations. So whether the child's future is clearly seen to lie in the UK, again, the child's parents' circumstances, if applicable, residence in the UK, and the child's immigration status, and any compelling or compassionate circumstances. Thank you. And finally, where none of the previously mentioned qualifying criteria are met, the Home Office will nevertheless consider granting citizenship to a child where exceptional circumstances are present, and they will have regard to the following key considerations. Whether the child's future is clearly seen to lie in the UK, again, the child's parents' circumstances if they're involved in the child's care and life, the length of residence in the UK, the child's immigration status, and any compelling or compassionate circumstances. And I quote here from the Home Office's guidance on their position on this, and they say, it may be appropriate to register a child with less residence if there are compelling or compassionate reasons, or refusal would cause the child considerable hardship. The Home Office will usually only exercise this discretion in the most extreme or exceptional circumstances, which may involve serious trauma having been endured by the child, serious health issues, and a need for citizenship and immediate stability, which could not otherwise be provided to the child through indefinite leave to remain, for example. Next slide, please. The last couple of considerations it's worth noting on the subject of citizenship are here. So the UK allows dual nationality, but not all countries do. So if applying for British citizenship means losing another nationality, this obviously needs to be considered carefully before moving forward with any application. And this kind of final point here to just flag is this case of Re-Y in 2020, where the local authority applied for a child in their care to be registered as a British citizen in circumstances where the parents objected, and the court held that high court approval would need to be obtained, where the granting of British citizenship would mean the loss of a previous nationality or citizenship. So that's all I wanted to kind of cover on citizenship. I'll pass you back now over to Emma, who I think is going to talk about family members abroad and visa applications for them.
Thanks very much, Laura. Just one thing that I would add about sort of nationality applications that are discretionary based on exceptional and compelling circumstances. I think we're all finding as practitioners that the Home Office has tightened up its approach to these applications quite significantly. I would say a few years ago, it was possible to make a successful application, particularly for a child in care, even where they didn't have indefinite leave to remain. Sometimes, but I mean, I wouldn't ever have done it without them having some sort of immigration status, but I often made applications where children had limited leave, and that seems to be, the Home Office has tightened up, and their guidance is much tighter now about where they will consider granting or registering a child on a discretionary basis. So it's always worth trying to regularise their immigration status before moving to the nationality application, I think. Anyway, moving on to visa applications from abroad, really looking at family members who might need to come either in for court proceedings or possibly to come in to care for a child on a long-term basis. And there are a few different categories of visa that might be appropriate in these scenarios, and these are often situations where advice might be needed for the court, and court support might be needed for a visa application as well. So the first of those is the visit visa route, and this is most likely to be applicable where family members need to come to the UK for court proceedings or for parenting assessments. A visit visa will be issued for it's valid for 6 months, so it means that a person can come to the UK for up to 6 months. One of the issues that can arise when family members are coming in, where there might be a sort of more long-term plan for that family member, is whether or not they are genuinely seeking entry as a visitor, because to be a genuine visitor, the person needs to show that they will leave the UK at the end of their visit, that they're not going to live in the UK for extended periods or make the UK their main home, that they're not going to undertake any prohibited, and that's the word in the rules, activities such as working or having NHS treatment, and also that they've got sufficient funds to cover all of their costs without working or accessing public funds. And so if you have a family member that's coming in for a parenting assessment, potentially with a view to remaining in the UK to care for a child that is currently in care, then a visit visa might not be the most applicable route. But it might be if they're coming in and then they're going to go back, and then the court might decide at a later stage. What I often do in these scenarios is I will make a visit visa application, but I will say that if the Home Office is of the view that the visit visa rules are not met, that this is a case that should be granted outside the immigration rules, and I'll talk a little bit more about that in a minute. The benefit, I suppose, of a visit visa application is that it's an application that is considered pretty quickly, and it's also an application that doesn't attract very high fees. The visit visa fee for a 6-month not multiple entry visa is just £127, which is significantly lower than any of the settlement routes, but it's only applicable if someone is coming in to visit and planning to leave again. Okay, next slide, please. So another visa route that might be applicable, and it's one that I've used a few times recently, is the parent of a child visa. And whilst it's called a parent of a child visa, it doesn't absolutely have to be a visa that is applied for by a parent. It can be someone that is in a parental role or wants to be in a parental role. And but the route is for parents or those in a parental role abroad who want to come to the UK to care for either British children or children who are settled here or who have pre-settled status, so the statuses that we've spoken about already. And the rules set out various requirements. They include financial requirements and English language requirements, but both of those can be waived in exceptional circumstances. And the reality is that in care proceedings, if you're looking to bring an adult in to care for a child or children who are currently in care, then there probably are going to be exceptional circumstances that mean that these requirements can be overlooked. And as I've said, the Home Office guidance accepts that a person who is not a child's parent may well have a genuine and subsisting parental relationship to a child where they're playing a genuinely parental role in a child's life. And that is sometimes something that really will be the case in care proceedings. I've made applications for aunts and uncles, grandparents to come in to care for children in care where the parents of the child may well be in the UK, but just not able to care for the children themselves. These applications are tricky. I'm not going to pretend otherwise, but if the exceptional circumstances of the case can be set out, and particularly if there is court support and local authority support for these visa applications, then I would say that they stand a reasonable prospect of success. Okay, next slide, please. Then, as I've mentioned before, it's always possible to make applications for visas that are based on exceptional circumstances, also known as outside the immigration rules applications. And when you're looking at children in care, there are almost inevitably going to be Article 8 family and private life arguments that can be raised as to why someone should be issued with a visa. And I suppose it really that one of the things with visa applications and with Home Office applications generally is that these applications succeed and fail on the evidence that is provided with the application. So it's not good enough just to make an application and send no documents in that set out the exceptional circumstances. It's really important for those circumstances to be well evidenced. You might have something from the court, you might have really detailed local authority supporting letters, you might have medical evidence. I mean, every case is going to be different, but that's the way that these applications succeed. Appendix FM of the immigration rules, which is the family migration part of the rules, provides that if there are exceptional circumstances such that refusal of an application would result in unjustifiably harsh consequences for the visa applicant, for their partner, for a relevant child or another family member, which amounts to a breach of Article 8 of the European Convention on Human Rights, then the application should be granted. Now, remember, Callum said earlier that Article 8 is a qualified right, and so the Home Office will carry out an assessment and will decide whether or not it's proportionate to grant an application with reference to Article 8. But if there are strong arguments about a child's care and someone not being cared for appropriately, if a family member is unable to come to the UK, then I would say there is a case to answer, and the Home Office, in my experience, is often quite responsive and receptive to those arguments. And then just to mention that a relevant child is defined in Appendix FM as a person under the age of 18 at the date of the application, where it's evident that from the information provided. And so this, again, it's really essential in the information and the letters that go in, that it's clear that there is a child that's going to be affected by any decision to refuse. And these, obviously, each of these cases is going to be very specific on its facts, but there are lots of cases in the context of care proceedings and children in care where it's going to be possible to raise exceptional circumstances. Next slide, please. So then another area just to mention is immigration advice in family court proceedings. And it may well be that advice is needed for the children in care who are subject of the family court proceedings, but advice might also be needed for other people involved. So that could be their parents. Often there will be parents who have not got a clear or regular immigration status. It may be that the parents are outside of the UK and need advice about their status and any ways of arriving and coming to the UK. Or it could be other people involved in their care. So it may be that a child is living with a grandparent here already, or with another family member, or with somebody else. It could be a special guardian, in fact, where advice is needed, and the court will often ask or set out the need for immigration advice. And this is something that we as immigration lawyers can assist with. And it's often quite helpful for family court findings to be made that will help immigration cases. Has to be said that the Home Office isn't bound by anything that a family court says, and there's a case that established that from some time ago. But if there is a family court order or judgment that says a lot of really helpful things, that then the Home Office will take that into account, and the existence of a court order or findings, recitals that refer to immigration issues, then the Home Office has to take those factors into account. One thing to flag, I'm sure you are all aware of this, is that family court documents about children are not disclosable unless the court has given permission for disclosure of the documents. And there actually was a case where somebody was given a suspended prison sentence, a lawyer was given a suspended prison sentence for disclosing family court documents where there hadn't been permission given for disclosure. And so it's really great to just have at the front of your mind that in court proceedings, every court order should, if there are immigration issues, every court order should provide for disclosure to immigration lawyers, to the Home Office, and also to the appellate authorities, because if a case goes to appeal, then disclosure to the Home Office doesn't cover disclosure to the appellate authorities. So all of those should be covered. There is a bit of a disagreement about whether just a court order can be disclosed without formal permission of the court. And the Immigration Law Practitioners Association is of the view that a court order by itself probably doesn't need specific disclosure, but the Home Office certainly doesn't agree with the Immigration Law Practitioners Association. And I think the headline is that it's always worth just getting that permission in court orders. Okay, next slide, please. So application process and timelines. The process is almost always an online process now. There are paper applications for a few applications in very limited circumstances, mainly nationality applications. Once the application is submitted online, at that point, any fees that are payable, and I'll come on to this in a moment, are paid. And after that, once the application has been submitted, the supporting documents will normally be uploaded electronically. They are very occasionally sent to the Home Office, but that's very unusual. And the applicant has to attend a biometric appointment. This is usually somewhere local, a service centre that isn't operated by the Home Office, but sometimes they will go to the Home Office and they'll have their fingerprints and photographs taken. If they're a child under 5, they'll just have their photographs taken. And they do normally need to have some form of ID, ideally a passport, but a birth certificate for a child should be good enough to go to a biometric appointment. And then the application is considered. Some applications have set service standards, others don't. For settlement, indefinite leave to remain applications, the set service standard is normally 6 months. For a lot of other exceptional circumstances applications, the service standard is there isn't a service standard. The usual processing time at the moment is about 12 months, which can seem like an incredibly long time. And others, as visit visa applications from abroad, are normally decided within 3 weeks. Family settlement visa applications from abroad are normally dealt with within 12 weeks, and there is some scope to pay for priority if there is money to pay for that and to speed up those decisions. Now, we'd not be being honest if we didn't tell you that, and I'm sure you know, that some applications do get refused. There are usually ways to challenge any refusal. That might be by way of an appeal through the immigration appellate authorities, through the first tier tribunal, and then the upper tribunal and up to the Court of Appeal if need be, hopefully not. Some applications do not have a right of appeal and only have a right of administrative review, which is a much less far-reaching remedy. It's the Home Office looks at administrative reviews themselves and decides whether or not a case working error was made. And some applications don't have either a right of appeal or a right of administrative review. And in those circumstances, the way to challenge a decision is only really by way of judicial review, which is a public law process started either in the upper tribunal, immigration and asylum chamber, or sometimes in the administrative court of the High Court, depending on what it is you're challenging. And you need to show that the decision has been unlawful or unreasonable or procedurally unfair to be able to succeed. And judicial reviews can be very costly and can result in cost orders being made against you to cover the Home Office costs if you are unsuccessful. So next slide, please. Fees. So you probably are all aware that children who are looked after by a local authority do not have to pay fees for their leave to remain, indefinite leave to remain, and nationality applications. And what that actually means is defined in the provisions that I've quoted. I won't quote them all there, but in England, this includes children who are being accommodated by a local authority under Section 20 of the Children Act. But just to flag, it doesn't include children that are being supported under Section 17 of the Children Act. So, and what Callum said earlier about making applications for indefinite leave to remain is one of the reasons that we would always recommend doing that really is because children in care don't have to pay fees. Why not ask for indefinite leave to remain on an exceptional basis, knowing that as the fallback position, that child should be granted a period of limited leave to remain. But fees for other people are payable. It's only children who are being looked after by a local authority that don't pay fees. So next slide, please. Fees are otherwise payable at varying rates, and some of them are pretty hefty. I've mentioned the visit visa fee, which is not so large, but a parent of a child visa from abroad is £1,938. and leave to remain applications from inside the UK are £1,321. Indefinite leave to remain applications actually cost more than that. They're £3,029 at the moment. And applications on a route to settlement, so not for indefinite leave to remain, but on a route to settlement, also have to pay the immigration health surcharge, which is £1,035 for adults per year of leave applied for. So these fees are really hefty, particularly if you're looking at a family making applications. There is scope to make applications for fee waivers, and these can be made for in-country applications and visa applications that are based on human rights. So Article 8 applications are human rights applications, and fee waiver applications can be made. An applicant has to show they can't afford to pay the fee. And applications need to be backed up by very detailed evidence of finances, and they can take a while to be decided. If refused, the fees then do have to be paid to proceed, but hopefully it will normally be possible in these kinds of circumstances to make a successful fee waiver application. Next slide, please. Just flagging legal aid. So legal aid is in scope and should be available for separated children for immigration and nationality applications. It's out of scope for other immigration cases, but there is something called exceptional case funding, where if you can show that being refused legal aid would infringe rights under the European Convention on Human Rights, then funding will be granted by the legal aid agency, but it does require an application to the legal aid agency before the funding is provided. Legal aid is means and merits tested. However, you probably all know how difficult it can be to find a legal aid lawyer. There is really an immigration legal aid desert out there, and it's very hard to find someone to help on legal aid. Just to say, OTB Legal has a legal aid contract for public law, so we are able to help on a legal aid basis in cases that might involve judicial review, but we don't have legal aid contract to help with immigration and nationality applications, unfortunately. Next slide, please. I will come on to how we can help, but just before I come on to that, just going to very quick mention of what the future holds. You may be aware that the government published a white paper in May 2025 about restoring control over the immigration system. And one of the things that it included was a plan for earned settlement and citizenship, with qualifying periods increasing for both. The details aren't really available yet. There's going to be a consultation apparently announced by the end of the year about the settlement provisions, and there is already a call to evidence open from the Home Affairs Committee. But one thing that I just wanted to flag is that the white paper specifically mentioned that changes to settlement will include ensuring that children who've been in the UK for some time, who turn 18 and discover they don't have status, are fully supported and able to regularise their status and settle, and also that there'll be a clear pathway for those children in care and care leavers. So it will be interesting to see what is set out and whether it is just turning what already exists for children in care in Home Office guidance into something that's in the immigration rules. So we'll just have to wait and see on that. So next slide, please. Before we look at your questions, just to say, how can we help you? So we normally offer a free initial consultation where we can discuss your needs and then provide a detailed quote for any work that's required thereafter. And you can book in for a free initial consultation. If something's urgent, we can usually fit you in pretty quickly. We then offer advice packages, which we charge at £360, including VAT. For immigration applications, we charge fixed fees and I've set out the prices there. The prices for nationality applications are a little lower because they tend to be slightly less involved. If you've got sibling groups, then we can probably look at offering slightly lower fixed fees for more than one applicant that's based on the same facts. And we can also help with court reports. We tend to charge those on an hourly basis at our hourly charging rate of £240 per hour, including VAT. So there you have it. Thank you very much for attending. That's the end of our presentation. I think we've got a few questions in the Q&A. So I don't know, Callum, do you want to share those with us?
Yep. So one question has come in what is the implication if leave to remain has expired before a Home Office decision has been made or refused? So I think this really relates to Section 3C primarily. Yeah, I think Emma set out earlier that so long as an application is made before an applicant's permission expires, all of their existing conditions, their existing leave continues whilst the application is still outstanding. If an application is refused and the previous grant of leave has already expired, then unfortunately the applicant at that stage will be without permission, and obviously steps would need to be taken to remedy that. Precisely what steps you'd need to take would obviously be dependent on the circumstances and the application that's been made.
Unless they have a right of appeal and they put in an appeal, and then Section 3C would continue. Yeah. So, but unfortunately, if someone makes an application after their leave has expired, that the making of an application doesn't give them their leave back. They've lost it, and they'd only get their leave back after a decision was made, if positive.
You mentioned social workers can give advice where they have a court order to look after a child. Does this mean they cannot do so where a child is looked after under a Section 20 voluntary arrangement?
That's a really good question. I mean, there's been a lot of stuff flying around on chats that I am a member of at the moment about this. So the recent guidance that I quoted on the slides did seem to suggest that there needed to be a court order for social workers to be able to assist children in their care. However, I mean, I think it's arguable. I don't think I would want to say categorically that where you've got a child that is being looked after under Section 20, that social worker has I think it's slightly different because you don't have parental responsibility if it's a Section 20 arrangement. The local authority only has parental responsibility, as I understand it, if a care order's been made. It might be something that it would be worth checking with the IAA to see what their view is on that. And I feel fairly sure that quite a lot of social workers do make applications where there are children who are being supported under Section 20, but I think I would be cautious about it, and it would be worth getting some clarity from the IAA.
Okay, next question was, for grants of limited leave, how do we then access entitlements for that child around rights to work and public funds? It seems we can't get past the e-visa barrier to being able to access these entitlements through the share codes generated by the e-visa. I think the e-visa actually is something different, isn't it?
Well, but the e-visa should reflect whatever conditions are attached to a child's stay. So I suppose if their stay is one that doesn't allow them recourse to public funds, then that might be a problem. And this isn't something that we talked about, but there is a way of approaching the Home Office to ask for a change of conditions that would allow a child to be given recourse to public funds. If they're granted 4 years leave under the child in care policy, then that leave is supposed to be with recourse to public funds. But I have seen recently that it's not always granted with recourse to public funds, and sometimes the conditions do say no recourse to public funds, but that should be challenged. And I think that can be successfully challenged because the policy guidance makes it clear that they should be granted recourse to public funds. I think maybe that's something to take up in particular cases. It's hard to know without knowing what the children's rights are, but I would have thought if they've been granted leave to remain, they would always have some sort of access to work as well if they were old enough to work. I'm not sure, Laura or Callum, whether you have anything to add to that.
No, sounds possibly like it could be an error with the e-visa, but obviously
might be an error with the e-visa. Yeah.
Okay. There's a couple of questions on, well, there's one on the expected timeline, but I think that came in before you actually covered timelines for applications. And then there's one on fees and whether fees can be waived for over 18s who are still supported under Section 20 by the local authority. And in particular, can fees be waived for settlement applications for indefinite leave to remain?
Okay. So I'm just looking at the question as well. So the question about timelines. I mean, one thing that's worth saying is that if an application goes in for a child when they're under 18, but remains outstanding and they turn 18, then that application, there's Home Office, it's very clear that the Home Office has to consider that application based on them being a child. So the fact that they've turned 18 whilst it's under consideration shouldn't affect the application. In terms of fee waivers and fee exemptions for care leavers who've turned 18, unfortunately, I think that the fee exemptions definitely do not apply after someone's turned 18, but there is the fee waiver route, and so I would definitely recommend doing that. If you've got a care leaver who has very limited income, then they should qualify for a fee waiver. The other question about fee waivers for indefinite leave to remain is, unfortunately, the answer to that is they are not available. But what you can do is get a fee waiver for a limited leave application, make the limited leave application with the fee waiver and ask for indefinite leave to remain on an exceptional basis. It's quite difficult to achieve that. And so really, I think probably the easier thing would be to pay the very hefty, if you can afford to pay it, pay the hefty indefinite leave to remain fee. But otherwise, you can apply for limited leave, but ask for it. And that there's Home Office guidance that makes it clear that you can do that. But as Callum talked about in his presentation, you need to show something exceptional for indefinite leave to remain to be granted on an exceptional basis. Did I answer all of the things you raised, Callum?
Yes, you did. There is a question actually on asylum applications as well and the time frame for those. So I think we just need to make clear that we don't normally advise on asylum claims as well.
Yeah, and sorry, I should have said at the beginning of the presentation that this was not going to cover asylum because it's beyond our area of expertise.
Next question. Yeah, this is a nationality question. So if a parent obtained British citizenship by naturalization and then moved abroad and gave birth to a child, would that child be automatically British, or are there other criteria that they must follow?
Yeah.
So, yes.
Yeah, so that parent, if they naturalised in the UK, they're a British citizen otherwise than by descent. And if they gave birth to a child outside the UK, that child should automatically be British, and it should be possible to apply directly to the passport office for a British passport without having to make a registration application and going via the Home Office.
Okay. Next question is, how can we make applications for children on a care order where parents are unwilling to provide their own ID documents and haven't applied for pre-settled status for themselves? Anybody wants to take that?
Shall I take that?
Yeah.
It's obviously more difficult than if you've got cooperative parents and ID documents, but it may be that you're able to get hold of some information from the Home Office, or it may be that if the child was born here, that you can get a birth certificate. I mean, I think really it depends on the child's circumstances, and every case will be different, but there's certainly ways of making applications where parents aren't cooperating and don't have their own, and so there's no access to the parents' ID documents. But hopefully you might be able to get some information from the Home Office that would help you in those circumstances. And in fact, if the parents are unwilling to help, that can often be helpful to an application for a child in care in a way, because you can make an argument that they need to be, their situation needs to be sorted out and their parents aren't helping, and therefore they need to be given some form of leave to remain irrespective of their parents' lack of cooperation. But I would say it really depends on the case in question. If it's under the EU settlement scheme, and I'm just looking at the question and wondering whether the mention of pre-settled status means that it's under the EU settlement scheme. I think without documents it can be quite tricky, but the Home Office is quite open to helping children in care who make applications under the EU settlement scheme. So it would probably be worth contacting them and seeing if you can get any support from them.
Okay. Next question. I don't know if this relates to Laura's slides. It says, did we say parental consent can be irrelevant if a parent is not involved in the care of a child?
For no, I think largely for citizenship applications, parental consent is generally going to be required. I think one of the considerations was the parent's immigration status. And normally the Home Office want to see that where the parents are involved in a child's care, the parents have status themselves and ideally indefinite leave to remain themselves. So that's where I think I mentioned that's going to be less relevant, their immigration, the parents' immigration status, rather than the consent aspect.
Having said that, though, I mean, I've certainly made applications without parental consent, where if it can't be obtained, and if the parent either is not around or not prepared to cooperate, then I don't think that by itself would be a reason necessarily to refuse a nationality application. And there is certainly some guidance about that so yeah, something that if it's a problem, it's something that we could certainly give you some guidance on.
Yeah, next question. If a parent has EU settled status and they have a baby who then comes into our care, can we apply for settled status for the baby? I suppose to a large degree, it depends on actually what status the parent had when the child was born. If they had settled status, then the child actually will be born British if they were born in the UK. But it's yeah, largely dependent on the circumstances of the parents at the time of birth. Don't know if either of you got anything to add to that.
I think if the parent hadn't had, I'm trying to think that there might be some provisions that if the parent was granted settled status after the baby was born, well, again, there would be there'd be a route to registering the child if the child was born in the UK. So I think that definitely, if a parent's got settled status, there are definitely ways either of obtaining British nationality for the child if they weren't British already at birth, and certainly at worst case scenario for getting them some immigration status if their parents got settled status.
Okay. Next question is on adoption. Can we apply for babies who have not been in the UK for enough years and there is a plan of adoption? Does adoption impact applications that can be made?
Oh, well, I mean, I think you could, but if a baby's going to be adopted, I think I might be wrong. No, if a baby's adopted and it's a UK adoption order, then that baby becomes British if they're adopted by by parents of whom at least one is a British citizen at the date of the adoption. So there may not need to be any steps taken, but I think there's also there definitely you can always apply. You can apply for anybody. They don't need to have been in it. There isn't a certain number of years that a child needs to be in the UK to make an application. And if they're in care, then at the very least they would be given 4 years leave to remain under the guidance for children in care. And actually, I often find that if you've got young children, the Home Office is more likely to grant indefinite leave to remain straight away than with older children. So certainly there isn't they don't have to have had a certain period of time. Or are you talking about, if you're talking about nationality, I'll throw it over to Laura. But I think nationality wise, I think the normal expectation is that a child's been in the UK for 2 years before you apply. But I think if they're not 2 years old, then that wouldn't be imposed if there was a reason for applying. Do you agree, Laura?
Yeah, I think so. And I think there's probably some guidance on adopted children as well, in terms of nationality registration applications, in circumstances where, yeah, British citizenship isn't automatically acquired on adoption, and when a registration application can be made.
Okay. Next question is on how one can evidence that they will not undertake prohibited activities. So I think this is in the context of visit visa applications, particularly NHS treatment given illness is not planned during the period in the UK. I think it's more about sort of showing the genuineness of the visit, and I suppose the incentives to leave the UK at the end of the visit, such as ties to their home country. Not sure if either of you got anything to add to that.
No, not really. I mean, I suppose some people who come to the UK as visitors might have private health insurance that would mean that they could show they don't intend to access NHS treatment. But of course, you're right that someone could fall ill, and in fact, you can access primary health care here as a visitor. What you can't, and you can accident and emergency treatment as well. It's just if you fall outside of either of those, then you will end up getting a massive bill for anything that you any NHS treatment that you have. So it is very definitely a good idea not to need it or to have some health insurance.
Okay. If both parents are resident in the UK but do not have immigration status, however, the child and older siblings were born in the UK, can we apply for settlement for the child? The child is being looked after by the local authority and parents are from the EU. I suppose, yeah, I mean, in theory, it kind of goes back to the slide I presented earlier on indefinite leave to remain, where it may well be worth, if the child's under the care of the local authority, making an application on that basis. But obviously it's partly dependent, I think, on the circumstances of the child.
And it may be that they're eligible to apply to register as a British citizen as well, depending if they were born here and have lived here for 10 years, then they would be eligible to register as British. So just will depend on the circumstances.
I mentioned the circumstances as well, but if they've been here, if the child was born in the UK and has been here for 7 years, they'd have a settlement application on the private life route as well. Young people who left care at 18 before applying for naturalisation, do they pay fees?
Right, so
yes. Okay, and then I think there's only one other question, but it relates to asylum applications, and the fact that unfortunately a lot of them are very delayed at the minute. But I don't think there's really anything we can add to that at the moment, unless you have anything.
Oh, and then there's a comment about the re-Y case.
Oh, yes, 2 comments actually.
Yeah. I mean, it's quite right that adoption regulates someone's British nationality. I think it was just to flag really that the Home Office, if you're applying to register a child as British, and they might lose another nationality by making that application, that the Home Office might say, well, have you got any court confirmation that this is acceptable? And it really will depend. I mean, I think these children were Indian, and India doesn't allow dual nationality. So but thank you for that, Sian, for the insight. And sorry, I should have said at the beginning, if I didn't, that we will be sending you the slides. Yes, is that all the questions?
I think it is. Yeah.
Well, I think I was going to say, and I didn't say, that I think if we could leave you with 3 things to take away from this, or maybe 4. The first thing is that we are here and able to help with all sorts of things, and we've set out what we can do and what our prices are on the slides, and you will get a copy of the slides. The 3 things that are more to do with making sure that children in care get the immigration advice and support that they need. One is to just bear in mind to always act if you can, and I appreciate that you have lots of things on your mind, but always act if you can before a child turns 18. It's much harder to resolve things for adults than it is for children. Just also, if they have limited leave, extend it before it expires. And finally, in court proceedings, please do get permission for disclosure of documents as well as orders, so that we can help you make good applications and not have to hang around waiting for an application to be made to the court for permission to disclose at a later date. So on that note, thank you very, very much for attending. Thank you to my co-presenters, Laura and Callum. And please do feel free to get in touch with us if you require advice and assistance in relation to the things that we've been talking about. We will say goodbye.
Thank you.
Thank you.